please. Can I have your name and date of birth, please, sir?
Nathan Valdez, May 2nd, 1994.
Thank you, Mr. Valdez. You are here on allegations of new charges. The allegations against you are 5 counts of trafficking in stolen property. They are all Class 2 felonies. 6 counts of burglary, all Class 4 felonies, and 1 count of possession of burglary tools, a Class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 8th and then a preliminary hearing April 10th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. Because all of these new allegations are felony offenses alleged to have been committed while you were on pretrial release in a different felony case, you are not eligible for release on bond. That means you will be held in custody without bail at least until an evidentiary hearing is held. That hearing is scheduled for April 9th at 1:30 in the afternoon. Between now and that hearing on April 9th, you will be held in custody without bond. Do you understand that information? I need you to say yes or no. Thank you very much, Mr. Valdez. You can step back and get your paperwork. Christopher Riley to the podium in the courtroom, please. Jeanette Garcia, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
9/23/85.
Thank you very much, Mr. Riley. You are here on 3 different matters. The first matter that you're here on is allegations of new offenses. Those allegations are 1 count of armed robbery, a Class 2 felony, 1 count of theft of a means of transportation, a Class 3 felony, 1 count of theft of a means of transportation as a Class 5 felony, 1 count of burglary, a Class 4 felony, 2 counts of unlawful flight from law enforcement, both Class 5 felonies, 1 count of failing to stay at the scene of an accident, a Class 1 misdemeanor, and 1 count of reckless driving, a Class 2 misdemeanor. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings on those new allegations will be a status conference April 8th and then a preliminary hearing April 10th. Both of them will take place at 8:30 in the Superior Court downtown. On the new allegations, I have imposed a $75,000 secured appearance bond. The second of the 3 matters you're here on is an allegation that those new charges violated term 1 of your probation. I've appointed a lawyer to represent you in the probation proceedings. Your next court hearing in that probation matter will be a revocation arraignment April 9th at 8:30 in the probation court downtown. On that matter, you have a $2,500 secured appearance bond. The last matter that you're here on is a failure to comply with court terms warrant issued by the Manistee Justice Court on an underlying misdemeanor driving on a suspended license case. In that case, you're entitled to a court-appointed lawyer for purposes of release conditions, and I've appointed one for you. Your next hearing in that matter will be an arraignment hearing April 8th at 10:30 in the morning. That hearing will take place in the Manistee Justice Court. On that warrant, you have a $50 secured appearance bond. So your total bond for all 3 matters will be $7,550. It is all secured appearance, which means that you can use a bonding company to post that. If you do post that bond and you are released from custody, you cannot return to the scene where any of the new alleged offenses took place. You cannot have contact with any alleged victims or witnesses of those offenses. And you cannot possess any weapons, alcohol, or drugs without a valid prescription if you're released from custody. Do you understand those conditions?
Yes, sir.
Okay, thank you very much. You can step back and get your paperwork. Derek Barnes to the podium in the courtroom, please. Enrique Lozano, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Derek Barnes.
Thank you very much, Mr. Barnes. You are here on an allegation of a new charge. That allegation is 1 count of unlawful flight from a law enforcement vehicle. It is a Class 5 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference April 8th and then a preliminary hearing April 10th. Both of those hearings will take place at 8:30 in the Superior Court downtown. On this allegation, I have imposed a $5,000 secured appearance bond. If you post that and you are released from custody, you cannot possess any weapons or drugs without a valid prescription. And if you are released, you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions? Okay, thank you, Mr. Barnes. You can step back and get your paperwork. Jeanette Garcia to the podium in the courtroom, please. Patrick Kelly, if you would please work your way to the second chair. Patrick Kelly. Officers, will one of you wake Patrick Kelly up? Thank you very much. Can I have your name and date of birth?
Garcia, 62486.
Thank you very much, Ms. Garcia. You are here on two different matters. The first one is a bench warrant issued by the Superior Court when you failed to appear at a sentencing hearing in an existing felony drug paraphernalia case. You have a lawyer on that case already. That lawyer will continue to represent you. Your next court hearing in that matter will be a status conference April 10th at 8:30 in the Superior Court downtown. On that warrant, you have a $500 secured appearance bond. The second matter that you're here on is a failure to appear warrant issued by the Pinal County Superior Court on a different felony drug case. If you don't already have a court-appointed lawyer representing you in that Pinal County case, you're entitled to one at a minimum for purposes of release conditions. If you don't already have a lawyer, the Pinal County judge will appoint one for you at your next court hearing. Your next hearing on the Pinal County warrant will be an arraignment hearing April 7th. That one will also be at 8:30, but it'll be in the Pinal County Superior Court. On that warrant, you have a $1,000 secured appearance bond. So your total bond will be $1,500. It is all secured appearance. If you post that and you're released from custody, please remember that you will then have to get yourself to your hearing on April 7th in Pinal County and then be back for your hearing in Maricopa County on April 10th. Also, if you're released from custody, you cannot possess any drugs without a valid prescription. Do you understand those conditions? Thank you, Ms. Garcia. You can step back and get your paperwork. Enrique Lozano to the podium in the courtroom, please. Andrew Johnston, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Yes, I'm 7.7.
And what's your name?
Lizama.
Thank you very much, Mr. Lozano. Let me get through what I have to, and you can ask any questions you have at the end.
I just want to know if it was rain.
Oh, I don't know.
Okay.
I don't know the answer to that. Okay. You're here on allegations of new charges. The allegations against you are one count of dangerous drug possession, that's a class 4 felony, and one count of drug paraphernalia possession, a class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 8th and then a preliminary hearing April 10th. They will both be at 8:30 in the Superior Court downtown. And on these allegations, I have imposed a $750 secured appearance bond. If you post that and you are released, you cannot possess any drugs without a valid prescription. Do you understand those conditions? Okay, thank you, Mr. Lozano. Patrick Kelly, if you would please work your way into the courtroom. Rachel Shea, if I could ask you to please work your way to the second chair. Can I have your name and date of birth, please, sir?
I think Leslie Kelly, 2257.
Thank you very much, Mr. Kelly. You are here on two different matters. The first matter that you're here on is a bench warrant issued by the Superior Court when you failed to appear at a status hearing. It looks like in a post-conviction drug court. You have a lawyer assigned to you in that case already. That lawyer will continue to represent you. Your next court hearing in that matter will be a status conference April 7th. It'll be at 9:30 in the morning in the Superior Court downtown, and you have a $100 cash-only bond on that warrant. The second matter that you're here on is an allegation of a new charge. That allegation is one count of burglary. It is a class 4 felony. I have found probable cause to support that allegation, and I've appointed a lawyer to defend you against it. Your next court hearings on the new allegation will be a status conference April 8th, and then a preliminary hearing April 10th. Those two hearings will also be at 8:30, also in the Superior Court downtown. On that new allegation, you have a $500 secured appearance bond. That means your total bond for these two matters will be $600. 100 of it is cash only. If you post that bond and you are released from custody, you cannot return to the scene where the alleged new burglary took place. You can't have contact with any alleged witnesses of that allegation. You also cannot possess or consume any alcohol or drugs without a valid prescription if you're released from custody. Do you understand those conditions? Thank you, Mr. Kelly. You can step back and get your paperwork. Andrew Johnston to the podium in the courtroom, please. Daniel Crosswaity, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir? Thank you very much, Mr. Johnston. You are here on 4 different matters. The first matter you're here on is a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. You have a lawyer already assigned to you in that case. That lawyer will continue to represent you. Your next court hearings on that case will be a status conference April 8th and then a preliminary hearing April 10th. They will both be at 8:30 downtown. And you have a $500 secured appearance bond on that warrant. The next 2 matters that you're here on are both failure to comply with court terms warrants issued by different justice courts. The first one was issued by the Ironwood Justice Court on a misdemeanor driving on a suspended license case. The second is a failure to comply warrant issued by the Kyrene Justice Court on a misdemeanor threatening and intimidating case. On both of those misdemeanor warrants, you're entitled to a lawyer for purposes of release conditions, and I've appointed one for you. Your next court hearing in each of those 2 matters will be April 4th at 8:30. On each of those 2 warrants, you have a $50 secured appearance bond. The final matter that you're here on is allegations of new charges. Those allegations are 1 count of dangerous drug possession, a class 4 felony, and 1 count of drug paraphernalia possession, a class 6 felony. I did not find probable cause to support those new allegations. My finding of no probable cause does not mean they are legally dismissed. It is possible that the county attorney's office will file formal charges on them. Because that is a possibility, I have appointed a lawyer for you in the event that charges are filed. I'm also going to give you 2 court hearing dates for these new allegations. The first one is a status conference April 17th, the second a preliminary hearing April 21st, both at 8:30 downtown. It is possible, Mr. Johnston, that you will go to court on April 17th. The court will say nothing's been filed, you're free to go. If that is not true, though, and if the county attorney files charges on this and you don't appear at that court hearing, that court will issue a warrant for your arrest. So no additional release restrictions on the new allegations, but you do have a total bond of $600 secured appearance on the 3 warrants that you're here on. If you do end up posting that bond and you're released, please make sure that you understand it will be your responsibility to get to all of your next court hearings. All of your hearing dates and times and the addresses for the court will be in your release paperwork, so please keep all of those so you know when and where to go to court. Last, if you are released from custody, you cannot possess any drugs without a valid prescription. Do you understand all of that information? Okay, thank you very much. You can step back and get your paperwork. Rachel Shank to the podium in the courtroom, please. Brandon Gaelko, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Rachel Shank, 4/16/87.
Thank you, Ms. Shank. You are here on a bench warrant issued by the probation court. It is a warrant that was issued when you failed to appear at a probation revocation arraignment hearing. You have a lawyer assigned to you in that case already. That lawyer will continue to defend you. Your next court hearing will be a new revocation arraignment hearing. It will take place April 9th at 8:30 in the probation court downtown. On that warrant, you have a $250 secured appearance bond. If you post that and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you very much. You can step back and get your paperwork. Daniel Crosswaity, if you would please work your way into the courtroom. Sydney Ramirez, if I could ask you to please work your way to the second chair. Can I have your name and date of birth, please?
Daniel Crossway, 04/13/1995.
Thank you very much. It's pronounced Crossweight.
Crossway.
Okay, thank you, Mr. Crossweight. You are here on allegations of new charges. The allegations against you are 1 count of causing criminal damage, a class 6 felony, and 1 count of disorderly conduct, a class 1 misdemeanor. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 17th and then a preliminary hearing April 21st. Both of them will take place in the Superior Court downtown at 8:30 in the morning. I am releasing you to the supervision of pretrial services on these allegations with the condition of electronic monitoring. What that means is you will be released from custody. You do not need to post a bond, but prior to your release from custody, somebody from pretrial will install an ankle monitor on you. Once you are released on that ankle monitor, you are ordered not to return to the scene where the underlying allegations took place, and you cannot have contact with the alleged victim. If those orders mean that I'm ordering you not to return to your primary residence, you must find an alternate residence at least until your first hearing on April 17th. You can return to that location if you need to retrieve any personal items one time between now and the 17th. If you need to return to retrieve any items, you must be accompanied by a law enforcement officer to do that. You can make arrangements for that by calling the non-emergency number to any local police agency if you need to do that. You also cannot possess any weapons, drugs without a valid prescription, or alcohol once you are released from custody. Do you understand those conditions?
Yes.
Do you have a question?
No, I think I know how to go do it. I'm gonna go stay at my grandma's.
Okay. Very good. If you do need to return to get clothing, a toothbrush, anything like that, please call law enforcement before you just go back to that location.
Okay.
Okay. Thank you very much, Mr. Crossway. You can step back and get your paperwork. Brandon Gallecco to the podium in the courtroom, please. Brittany Bonney, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Welcome, January 13th, 1987.
Thank you very much, Mr. Gallecco. You are here on an allegation of a new charge. That allegation is one count of narcotic drug possession for transportation or sale. It is a class 2 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference April 17th and then a preliminary hearing April 21st. Both of those will be at 8:30 in the Superior Court downtown. On this allegation, I am releasing you to the supervision of pretrial services. That means you will be released from custody without having to post a bond. Once you are released from custody, you will be responsible for getting yourself to your next 2 court hearings. You will also be required to contact pretrial services. Their contact information will be in a packet that you get with your release order, so please keep it so you have their phone number to make that call once you're out of custody. Also, once you are released, you are prohibited from possessing any weapons or any drugs without a valid prescription. Do you understand those conditions? Thank you, Mr. Gallecco. You can step back and get your paperwork. Sydney Ramirez to the podium in the courtroom, please. Jose Sordo, if you would please work your way to the second chair. Can I have your name and date of birth, please?
It's Sydney Ramirez, 11/27/1987.
Thank you very much, Ms. Ramirez. You are here on allegations of new charges. The allegations against you are one count of causing criminal damage, that's a class 6 felony, and one count of assault, a class 1 misdemeanor. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 17th and then a preliminary hearing April 21st. Both of them will be at 8:30 in the Superior Court downtown. I am releasing you to the direction of pretrial services with the condition of weekly alcohol testing. That means you will be released. You do not need to post a bond. Once you are out of custody, you will be responsible for contacting pretrial services to set up that alcohol testing. Their contact information is in a packet that you'll get with your release order, so please keep that. Once you are out of custody, in addition to contacting pretrial services and getting yourself to your court hearings, you are also ordered not to return to the scene where the underlying alleged events took place or have any contact with the alleged victim or any witnesses. You also cannot possess or consume any alcohol or drugs without a valid prescription. If my orders combined mean that I'm ordering you not to return to your primary residence, you must find an alternate residence at least until your first hearing on April 17th.
Okay.
If you need to return to the location where these events took place because it is your primary residence, you can go back there one time and one time only between now and the 17th. But in order to do that, you have to be accompanied by a law enforcement officer. That process is called a civil standby, and you can make arrangements for that by calling the non-emergency number. Please don't call 911. Call the non-emergency number to any local police agency. Let them know you need an escort to that location. They will tell you what you have to do to get an officer to take you back there to retrieve any items you might need. Do you understand all that information?
Yes, ma'am.
Okay, thank you, Mr. Ramirez. You can step back and get your paperwork. Okay, Brittany Bonney, if you would please work your way into the courtroom. London Galindo, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Brittany Bonnie, April 29, 2000.
Thank you. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession, a class 4 felony, and 1 count of drug paraphernalia possession, a class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference April 17th, and then a preliminary hearing April 21st. Both of them will be at 8:30 in the Superior Court downtown. I am releasing you on your own recognizance, so you will be released from custody. That means it's going to be your responsibility to get yourself to both of your court hearings on the 17th and the 21st. Once you are out of custody, in addition to attending those court hearings, you are also ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Ms. Bonnie. You can step back and get your paperwork. Jose Sordo to the podium in the courtroom, please. Carlos Morales, if you would work your way to the second chair. Can I have your name and date of birth, please?
Jose Julian Sorto, date of birth, April 28, 1978.
Thank you very much, Mr. Sordo. You are here on an arrest warrant issued after a direct complaint was filed. A direct complaint is a written document that alleges a new allegation against you. The allegation in that direct complaint is 1 count of narcotic drug possession. It is a class 4 felony alleged to have been committed June 22nd of 2023. I have appointed a lawyer to represent you in that case. Your next court hearings will be a status conference April 17th and then a preliminary hearing April 21st. Both of those hearings at 8:30 in the Superior Court downtown. I am releasing you on your own recognizance on this warrant. That means you will be released from custody without having to post a bond. Once you are released, you will be responsible for getting yourself to both of your next court hearings, and you cannot possess any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Sordo. You can step back and get your paperwork. London Galindo to the podium in the courtroom, please. Can I please have your name and date of birth?
London Galindo, April 27, 2002.
Thank you very much, Mr. Galindo. You are here on an allegation of a new charge. The allegation against you is 1 count of assault. It is a class 1 misdemeanor. I have found probable cause to support that allegation, and I've determined that you are entitled to a court-appointed lawyer. That lawyer is going to be appointed for you by the next judge you see at your next court hearing. That hearing is going to be an arraignment hearing, April 22nd. It will be at 8:30 in the morning in the West Mesa Justice Court. I am releasing you on your own recognizance, so you will be released from custody without having to post a bond. That means it's going to be your responsibility to get yourself to your next court hearing. Once you are released from custody, you are prohibited from having contact with the alleged victim under any circumstances. You cannot possess any weapons. You cannot possess or consume any alcohol or drugs without a valid prescription. And you are strictly ordered to comply with the terms of any orders of protection if any have been or are later served upon you. Do you understand those conditions?
Yes, ma'am.
Okay, thank you very much, Mr. Galindo. You can step back and get your paperwork. Carlos Morales, if you would please work your way into the courtroom. Okay, good afternoon, sir. Can I ask you to state your full name and date of birth, please?
Carlos Morales, August 19, 1988.
Thank you very much, Mr. Morales. And it looks like I have lawyers appearing in this matter on both sides. I have the state in the courtroom. It looks like defense counsel on the electronic, what do we call this? On the computer. Okay,
Teams, good afternoon.
just one second, Mr. Green. I'm trying to get my computer or my camera situated so you can see me.
No problem, Judge.
Okay. All right. Can I please have the appearance of counsel for the state? Thank you. Good afternoon, Ms. Gaunt. Thank you for joining me. And appearance of counsel for the defendant, please.
Ben Green appearing on behalf of Carlos Morales, who's in custody. Thank you, Your Honor.
Mr. Green, I see your lips moving, but we're not hearing anything. Is this an issue on our? Are you on mute? It doesn't show you're muted, but I don't hear you.
I'm not muted.
I see you. I see your lips moving, but we're not hearing anything.
Still not muted.
Do we have a phone number? Mr. Green, do you have a phone near you that perhaps you could call for audio? Yes. Is there a phone number he can call? If so, can you tell me what it is? Do you know it, Ms. Gaunt? I'm sure there is. I'm trying to get a phone number for you, Mr. Green. Oh, you know what? I take that back. Mr. Green, I think I have your cell phone number in your notice of appearance. Is that the phone that's in your hand? What I'm going to do is call you from the bench phone then, and I'll just put you on speaker and we'll get your audio that way. Any objection to that, Ms. Gaunt? Okay.
This is Ben Green. Can you hear me?
I can. Good afternoon, Mr. Green. Okay. Can you mute or turn the speakers down on your computer because we're hearing it through the phone?
Got it.
Okay. All right. Thank you. If you would please give me your formal appearance for the recording.
Benjamin Carl Green appearing on behalf of Carlos Morales, who's in custody.
Okay. Thank you very much, Mr. Green, and thank you for being flexible and getting this working.
No problem.
Okay. Mr. Morales, you are here on allegations of new charges. The allegations against you are 8 counts of possession of a weapon by a prohibited person. They are all class 4 felonies. 1 count of disorderly conduct involving weapons, a class 6 felony, and 1 count of discharging a firearm in the city limits, also a class 6 felony. I will say that based on my reading of the Form 4, I am inclined to find probable cause to support these allegations. Before I officially do that, any argument, Mr. Green, in regards to probable cause?
Yes, Your Honor. I've read the Form 4. It appears that police were using an unmanned aerial vehicle, I'm assuming a drone, by looking for another vehicle. I don't know where the positioning was from where Mr. Morales was. They heard pops. He works in a mechanic shop. I don't know that it's clear that they could have heard or seen gunshots. It doesn't appear that they saw anyone shooting. That is the reason that led them to come to the property where they thought that this may have happened. It says that the defendant exited the property and was just detained. At that point, he just volunteered that he owned weapons, and I believe that there's a corpus delicti issue. No one saw him with the weapons. He just simply said that. Independent evidence doesn't seem to be there that they saw him shooting, knew what the pops were from. They weren't investigating him. And so it seems as though, I don't know that there's probable cause to go on his property. They did obtain a search warrant after the fact, but the search warrant is based upon the reasonableness of even coming onto his property. So I don't know. After that, they found weapons, and they found some expired 9mm shells, approximately 12. It doesn't say whether they were warm to the touch. It doesn't say in here whether there was a 9mm that was found inside of his residence. So this is a property, my understanding is, that has multiple people on it. It's a mechanic shop that is, he has a home that he lives at, but also this is where he stays sometimes for work. And so aside from what he may have said after Miranda, I don't know that there is enough to find probable cause for this charge without more information. Thank you, Your Honor.
Thank you very much, Mr. Green. Okay, response, counter argument in regards to probable cause, Ms. Gaunt.
Thank you, Your Honor. The Form 4 indicates that law enforcement that was on the scene at the time operating the drone heard several, it looks like they heard 2 to 3 pops.
If I could just stop you there just for one quick second. Mr. Green, can you hear her?
Yes, I can.
Okay, my apologies, Ms. Gaunt. Please
Thank you,
proceed.
Judge.
And an additional 5 to 7 pops. Law enforcement officers certainly have the training experience to be able to recognize the sound of gunshots. Additionally, at the time that the law enforcement made contact with law enforcement, he indicated that he'd heard gunshots on his property, and then volunteered that he had an AR-15 rifle. I think for probable cause purposes, there's enough information given that, and then the fact that once law enforcement entered the property, they found 12 9mm casings on the southwest corner of the property. I think that there's enough here for the probable cause purposes for the discharge charges. Additionally, in regards to the firearms that were located, unfortunately, the Form 4 doesn't say specifically that a 9mm was found, but it says there were both handguns and AR-15 style rifles that were found. It indicates that those were found inside what they're calling the defendant's bedroom, where there were also various pieces of documentation, including hospital paperwork and bills that had the defendant's name on them. So I believe, given all of that, there's enough information for the court to, and additionally, my understanding is the Form 4 indicates that the defendant stated and told the made admissions that he did in fact fire approximately 5 to 10 rounds towards the drone. Given all that, I think there's enough for the court to find probable cause for all of the charges.
Okay, thank you very much, both of you, for your arguments. Based on my reading of the Form 4, and for the benefit of you, Mr. Morales, I will tell you the court takes the information in the Form 4, which is the document submitted by law enforcement saying what happened. The court takes the information in that as though it is true and as though it will become evidence in court for purposes of a probable cause determination. Based on the information in the Form 4, I am finding probable cause. I hear your lawyer's arguments that he has concerns. It sounds like with the initial entry onto the property, potentially also concerns with the validity of the search warrant. I am not discounting or minimizing those concerns. I am simply saying that for purposes of this hearing, I am finding probable cause. Those remain valid concerns, valid arguments, but they will be for another time later in this proceeding. So I am finding probable cause to support the allegations. Mr. Morales, I have determined that you are entitled to a court-appointed lawyer. I have appointed the public defender's office to represent you. I know Mr. Green is here representing you today. His notice of appearance, the way I read it, is only for this hearing. You have the right to make an agreement with him or any other private lawyer for any matters after this hearing. Should you not make an agreement with him or any other lawyer, you will have a public defender assigned to you. If you do make an agreement with Mr. Green or another lawyer, that lawyer will know what to do to tell the court that they're going to take over and the public defender would withdraw. Okay, next court hearings in this matter will be a status conference April 8th and then a preliminary hearing April 10th. Both of those hearings will take place at 8:30 in the Superior Court downtown. Before I consider or impose any release restrictions or release conditions, in this case, I would like to hear argument and or recommendation, please beginning with the state, Ms. Gaunt.
Thank you, Your Honor. The state's asking for a $50,000 security repair fund. Our understanding is that Ms. Morales has a prior felony conviction.
I believe that's for theft from 2007. Our understanding is additionally that he was placed on probation for that conviction, and he was discharged unsuccessfully from probation. The allegations of the court is aware he was in possession of 8 firearms as a prohibited possessor. He allegedly shot at a law enforcement drone. There was a strong weight of the evidence as he made admissions to doing so. We believe, given the fact that firearms were used, that this is these are very serious charges, and we believe that he is a community safety risk, Your Honor.
Thank you very much, Ms. Gaunt. Okay, response, counter argument, recommendation regarding release conditions on behalf of your client, Mr. Green.
Yes, Your Honor. I would ask that the court consider pretrial service release or a much, much lower bond. Yes, the state is correct. I have the case in front of me. In 2007, he was convicted of a Class 6 theft along with a misdemeanor. That is, more than 10 years ago. For a Class 6 felony, the eligibility is 5 years. Many people that are convicted of a very low-level felony or any felony don't realize that they need to get their gun rights restored. And it's a problem that I encounter day in and day out. I represent many people in the restoration of civil rights, gun rights, and so forth. So this is an old prior. He's not been in any trouble since 2007, and that's a good thing. That being said, there's real questions about, I understand the court found probable cause and it's a low standard, but there's real questions about the validity of the search and so forth. There's real questions about whether or not there's no firearm residue maybe located on his hands and so forth. It could have been someone else. Statements alone are not enough. I would ask that the court impose, he also has an address here, 750 South McDonald. He's been in the state of Arizona for more than 10 years, at least until 2007. He has children. He is a United States citizen. He has a job. His employer contacted me. There are ongoing work that's going on right now on vehicles. He's a mechanic, and he needs to be released so he can attend to those things. I don't see him as a flight risk. He will have counsel, whether it be me or someone else. And I believe pretrial services with a low bond would be reasonable in the neighborhood of $2,500.
Okay, thank you very much, Mr. Green. Okay, Mr. Morales, I have reviewed your criminal history. I have considered the strength or lack thereof, I guess, depending on which lawyer is speaking, of the state's case in this matter. I do, like I said, note your lawyer's concerns about the entry onto your property and the search warrant. I do also hear and acknowledge the state's arguments that there are post-Miranda admissions to the allegations in this case, and that seems to be a pretty strong weight to be given to the allegations. I will tell you, I am inclined and persuaded by the state's argument that the nature of the allegations in this case does pose a substantial risk of harm to the community. Just generally speaking, I will say, regardless of the nature of the underlying felony, it causes the court some concern to see somebody that is a prohibited possessor, not only in possession of a firearm, but 8, potentially 9. The way that I read the Form 4, it sounded like upon execution of the search warrant, they found 8 additional weapons. So I know there are only 8 allegations, but it's possible that it's up to 9 weapons that were found in this case. I'm not making any ruling that it's 8 or 9. I just am trying to impose that we're not talking about just a single weapon. We're talking about many weapons, at least one of which was fired, based on the admission of the defendant, which I think that your lawyer intends to challenge. But for purposes of this hearing, I have an admission that shots were fired. I have at least 8 guns, and I have a prohibited possessor. And I do have substantial concerns about the safety of the community given those allegations. So I am going to impose a secured appearance bond in this case. I'm going to set it at $25,000. Secured appearance, Mr. Morales, means that you can use a bonding company to get that posted. I'm sure that your lawyer is well versed in how to go about that. I'm also sure that he will likely communicate that to your family. So you are free, if you have his number, you're free to use it to use the jail phones to call him. You can also communicate with your family. My guess is your lawyer's in contact with your family, so you can communicate that way in hopes of getting that bond posted. If you do post that bond and you're released from custody, please stay in communication with your lawyer and make sure that you are present at all future court hearings. You are also ordered not to possess any weapons while you are on release in this case. If there are weapons that you are in possession of that have not yet been seized by law enforcement, you will have to dispossess yourself of them. I'm not telling you that you have to permanently get rid of them, but at least while this case remains pending, you cannot be in possession of them. So you should give them to a trusted friend, family member. You can check them in with law enforcement. Your lawyer might have other options for disposing of temporarily dispossessing yourself of those weapons if you have any additional. Not that it was any allegation in this case, but you're also ordered not to possess any drugs without a valid prescription if you do post that bond and you're released from custody. Anything else we need to address before I excuse this matter, Ms. Gaunt? Okay, anything else on this matter, Mr. Green?
No, Your Honor, thank you. And I don't know what's wrong with my mic, but I've tried to turn it off and on. So thank you, Your Honor.
Okay, don't hang up though, because I think you have one more client, right?
I do.
Okay, all right. Thank you very much, Mr. Morales. You
I'll
can
be in
step back to your,
I'll be in contact with you, Mr. Morales, okay? I'll be in contact.
okay, all right. Thanks, Mr. Morales. You can step back and get your paperwork. Officers, do we have Mason Blumenthal in the courtroom? Okay, do we? Oh, he is going to be coming in though. Okay. I would prefer it because he's represented by a lawyer and he has the right to hear what his lawyer is saying. Okay. So if we can get him in here, that would be great. Okay. Sure, no problem. Mr. Green, just so you understand what's happening, it sounds like your client, Mr. Blumenthal, is being held in a safe cell. So MCSO needs a minute just to get him escorted into the courtroom.
Great, thank you, Your Honor. I'll mute
Give
myself.
us just a minute. Thank you. Well, I have you on audio, so.
Oh.
I can't mute you without hanging up on you.
Do you want to call another case, Judge?
He's the last one I have on my calendar.
Oh, okay.
Yes. Blumenthal? Oh, thank you.
Thank you.
Officer, I know you weren't in here from the beginning, but do you know why Roland Valdez isn't in here? Is he only not in the courtroom because he was a keep away? And if so, could we bring him in too? Okay, thank you. He's here, right, at ITR, not at Watkins or Towers or down the hall?
Mason?
Yeah.
He's here,
Okay.
but because what the observation is on, I think he might be like completely naked. We're gonna get him out, we need medical to check him. And then we'll bring him in, then when we take him back, medical needs to check him again, and then we need to take all the clothes.
Okay,
So it might take a little bit.
okay. Okay, I'm gonna read some house calls. So Mr. Green, you're gonna hear me talking, but I'm not calling the case and not acknowledging you.
No problem, Judge. Thank you.
Okay. Okay, number 3 on the calendar, Richard Jakowiak, date of birth 10/14/84, is not in the courtroom because he was unable to function in general population due to combative behavior. He is here on allegations of new charges. The allegations are 1 count of aggravated assault, a class 4 felony, 1 count of causing criminal damage, a class 6 felony, and 1 count of disorderly conduct, a class 1 misdemeanor. I found probable cause to support those allegations and appointed a lawyer to defend him. His next court hearings will be a status conference April 8th and a preliminary hearing April 10th. On those allegations, I have imposed a $25,000 secured appearance bond in addition to electronic monitoring and alcohol testing and monitoring through pretrial services. Okay, we have Mr. Blumenthal now?
Yeah.
All right, if you would work your way into the courtroom, please, Mr. Blumenthal. Thank you, officers. Okay, Mr. Blumenthal, can I ask you to please state your full name and date of birth?
Mason Marcus Blumenthal, September 20th, 2001.
Thank you very much, Mr. Blumenthal. And it is my understanding we have lawyers for both sides in this case. Can I please have the appearance of counsel for the state? Good afternoon again, Ms. Gaunt. Appearance of counsel for the defendant.
Benjamin Carl Green appearing on behalf of Mason Blumenthal, who's present in custody. Thank you.
Good afternoon, Mr. Green. Again, thank you for being here. Okay, Mr. Blumenthal, you are here on allegations of new charges. The allegations against you are 2 counts of unlawful flight from a law enforcement vehicle. They are both class 5 felonies. Based on my reading of the Form 4, I am inclined to find probable cause to support those allegations. Before I do that, any argument in regards to probable cause, Mr. Green?
Give me just one moment, Your Honor. I've read this Form 4 a couple times, but seems like for purposes of this case, we'll leave it to you to determine probable cause.
Okay, thank you very much, Mr. Green. Any argument regarding probable cause from the state, Ms. Gaunt?
No, yeah.
Okay, hearing no counter argument, I am finding probable cause to support those 2 allegations of unlawful flight. Mr. Blumenthal, you are entitled to a lawyer to defend you in these proceedings. Mr. Green's notice of appearance was for purposes of this hearing only. So for going forward after this hearing, I am appointing the public defender's office to represent you. You have every right to continue to have Mr. Green represent you or to hire another private lawyer if you choose to. If you do that, that private lawyer will know how to get the public defender to withdraw. But if no agreement is reached with any private lawyer going forward, you will have a public defender representing you. Okay, very good. Your next, well, before we go to next court hearings, let me start with release conditions, but lawyers, please don't let me forget to come back and give court hearings. I am notorious for that. Okay. Before then, I consider court hearings or release conditions. Can I please have the argument or recommendation regarding release from the state?
Thank you.
Thank you, Your Honor.
The state certainly thinks about the possibility of a bond in this case because of the seriously dangerous behavior, driving behavior, allegedly of Mr. Blumenthal. However, given the fact that he doesn't appear to have any prior criminal history, the state would have no objection at this time to pretrial services release with electronic monitoring. Additionally, we'd ask for alcohol and drug testing and monitoring. We'd also ask the court for prohibition against operating any motor vehicle. We do have some concern. I think that the state is very concerned that Mr. Blumenthal may have some mental health issues that may be happening at this time, as well as we are concerned about his aggressive behavior since he's been in jail custody. But I'm hopeful that given that an attorney is there representing him, that he will be able to attend all of his court hearings and comply with the conditions.
Okay, thank you very much, Ms. Gaunt. Recommendation, counter argument regarding release conditions on behalf of your client, Mr. Green.
I don't disagree with the state. A bond would be not beneficial here. I don't know that the court would release him. OR pretrial services seems reasonable. Everything seems reasonable. I am concerned about his mental health. I do know his father. I've spoken to his father today. I'm probably going to be getting on both these cases, and I'm going to for sure be getting on this case going forward. But I needed to get the Form 4. I have to talk to Mason to see what I gleaned from a conversation to see if it may be necessary to do Rule 11 evaluation on him. I don't know that what the court can order to the extent of mental health counseling, but I believe that he needs to be supervised by adult supervision, adult probation, ankle monitoring. I'll leave it to you, Your Honor. The driver's license suspension seems reasonable. So kind of just rattling off the same thing the state says. But yes, I have concerns for this boy. I know him, but I want him to be safe as well. And I want the community to be safe, and I want him to get some help if that's what he needs. Thank you.
Okay, thank you both very much. Mr. Blumenthal, I will echo the state's comments. I also initially thought it was appropriate to impose a bond on this case, not only because of my concerns for the safety of the community based on the nature of the allegations and the recklessness of the driving at issue. I also have some concerns based on the fact that allegedly you seemed to acknowledge law enforcement's presence, pull over, and then flee. I understand these are just factual allegations at this point, but those allegations give me some concern about your willingness to voluntarily consent to legal proceedings. I hear Mr. Green telling me, and also Ms. Gaunt telling me from the state that there might be underlying mental health issues or concerns in this case. I am not unsympathetic to that. I also agree with Mr. Green that to the extent the legal system has the ability to, we can attempt to get you some mental health help. I don't have the authority or ability to do that leaving this court, but Mr. Green or certainly any lawyer going forward will know how to petition the next court for any orders that are appropriate regarding mental health. I am going to accept and impose the recommendation sort of submitted by both lawyers. I'm going to release you to the supervision of pretrial services with conditions of electronic monitoring, alcohol, and drug testing. That means that you will be released from custody without having to post a bond, but you will be affixed with an ankle monitor prior to your release from custody. Once you are released from custody, you cannot operate a motor vehicle, at least while this case remains pending. You also cannot possess any weapons, and you cannot consume any alcohol or drugs unless you have a valid prescription for the drug. Okay. That order brings me to court hearings. Since I am not imposing a bond, the next court hearings in this case will be a status conference April 17th and then a preliminary hearing April 21st, both at 8:30 downtown. Anything else I need to address in this matter from the perspective of the state, Ms. Gaunt?
No, you're good.
Okay, thank you very much. Anything else I need to address from your perspective, Mr. Green?
One thing, Your Honor, I don't know if you have the ability to change the status conference. I'm out on a pre-planned vacation, 4/14 to 4/18. I don't know if we're able to move it earlier or put the status conference the week after on the 21st.
So the only ability I have to change that date would be to impose a bond, which would bump the hearing up, and I'm not inclined to do that in this case. So what I will encourage you to do, Mr. Blumenthal, is, do you know which judge this is going to get assigned to? So I can at least give him a name. Okay, so it looks like the underlying case is getting assigned to Judge Van Wee. So if you want to try to reach out to Judge Van Wee's division and see if, I don't know if a written motion would be required or if perhaps you could work some agreement out with either Ms. Gaunt or whoever is the prosecutor that's going to pick this case up, and see if you can do it by agreement, but you'll have to work that out with her division.
I'll do that, Your Honor. I can do that with her division. I've done it before.
Okay. All right. Very good. Anything else then?
No, Your Honor. Thank you for letting us appear. Sorry for the technical glitch.
No, that's okay. We got it done. Thank you very much for being here. Mr. Blumenthal, you are free to collect your paperwork and work your way back to your left. Your lawyer will be in contact with, it sounds like, your dad, and you can communicate with your dad and get information that your lawyer wants you to have. Thank you.
Thank you, Your Honor.
Oh, yes. Sorry, I think we're reprinting his paperwork. If you guys want to just wait 2 shakes. Okay. Ms. Cotton, you're free to be excused. Yes, thank you.
May I be excused?
Oh, I'm
as well?
sorry. Yes,
No,
I will
okay.
hang up on
No
you and you're
problem.
free to be excused.
Thank you. Thank you very much. Have a good afternoon. Bye-bye.
You too, thanks. Okay, number 18 on the calendar, Sierra Unique Farinas, date of birth 8/10/93, is not in the courtroom because she was unable to function in general population due to bizarre behavior. She is here on allegations of new charges. Those allegations are 1 count of narcotic drug possession for sale, a class 2 felony, 1 count of narcotic drug possession for use, 1 count of possession or use of a weapon in a drug offense, those are both class 4 felonies, and 1 count of failing to admit she was carrying a deadly weapon, a class 1 misdemeanor. I have found probable cause to support those allegations and appointed a lawyer to defend her. Her next court hearings will be a status conference April 8th and a preliminary hearing April 10th, both at 8:30 downtown, and I have imposed a $15,000 secured appearance bond on those allegations. Last on the calendar, number 15, Roland Valdez, date of birth 12/31/96, is not in the courtroom because he poses a danger to himself. He is here on allegations of new charges. Those allegations are 5 counts of trafficking in stolen property, 4 class 3 felonies, 1 class 4 felony, 6 counts of burglary, class 4 felonies, and 1 count of possession of burglary tools, a class 6 felony. I have found probable cause to support those allegations and appointed a lawyer to defend him. His next court hearings will be a status conference April 8th and a preliminary hearing April 10th, both at 8:30 downtown, and I have imposed a $10,000 secured appearance bond on those allegations. If anything changes after I visit any of these individuals' cell side, the court's final orders regarding release conditions will be reflected in their written release orders. That concludes the 2 p.m. initial appearance calendar. This court will stand in recess until 5 p.m.